A Mr. John Merriman, a member of the Maryland legislature, had been recruiting rebel soldiers. He was arrested by a Union general and hauled off to Fort McHenry in Baltimore Harbor. This was when Supreme Court justices still rode the circuit. They would hop on their horses or other carriages to serve as federal circuit judges around the country. When Merriman filed his request with his local circuit judge, he went to none other than Chief Justice Roger Taney, who was the circuit judge for that location. Taney was no friend of the Republican administration, and when he received Merriman's petition, he ordered the commander of Fort McHenry to bring Merriman to his court in Baltimore. Instead of complying, the commander sent back an aide bearing the message that the president had authorized the colonel, the commander, to suspend the writ of habeas corpus. This, as you can imagine, incensed Chief Justice Taney. He wrote a fiery opinion saying that only Congress had the power to suspend habeas corpus. The president's job, he said, was merely to see that the laws be, as the Constitution says, faithfully executed. President Lincoln did not publicly respond to Taney's opinion until Congress met a month later on July 4th. And taking aim at Taney's assertion, he noted that in the Confederacy, the Constitution itself was being ignored, and that had he not acted when he did, Washington, D.C. would have fallen into Southern hands, and there would have been no Congress to act in response to the rebellion. Lincoln famously asked, "Are all the laws but one to go unexecuted, and the government itself go to pieces, lest that one be violated?" Merriman stayed in jail, and scholars still debate whether President Lincoln had the authority as president to invoke the constitutional provisions suspending habeas corpus during the early days of the war. And I'm not going to wade into that debate tonight, but it suffices to note that in March 1863, Congress was in session and gave President Lincoln express legislative authority to suspend the writ, which then removed any constitutional obstacle to the detention of enemy Southerners. And I think to President Lincoln's immense credit, he did not use the authority he asserted to trample on the civil liberties that the writ of habeas corpus was meant to protect. I think recent studies have made pretty clear that President Lincoln did not try to suppress political dissent, and he understood that a democracy grows stronger by allowing people to voice their opposition to government, even in the midst of war. Now, he appreciated that the strength of the Union lay not only in force of arms, but in the liberties that were guaranteed by the open and sometimes heated exchange of ideas. And he no doubt would have been pleased to know that after his assassination and the conclusion of the war, President Lincoln's predictions that habeas corpus would quickly be reinstated came to pass. In Lincoln's words, "What constitutes the bulwark of our own liberty and independence is not our frowning battlements, our bristling seacoasts, the guns of our war steamers, or the strength of our gallant and disciplined army, but rather the love of liberty and the preservation of the spirit which prizes liberty as the heritage of men in all lands everywhere." In this way, what might otherwise be remembered as a clash between these two large historic figures can be seen as a moment of large respect, really, for the rule of law by both the President and the Chief Justice. The constitutional debate they sparked continues even now, but I think we can appreciate the character of the two men behind this story and their sincere, even if conflicting, examples of dedication to principle and to the people of this nation loom large even today. Now, a third well-known account of the intersection between the large scopes of influence of the judiciary and the presidency is, of course, contained in the story of President Franklin Roosevelt's court expansion plan, which you heard a lot about today. The current head count of justices is engraved neither in stone nor in the Constitution. There have been so many fluctuations in the numbers of justices on the court that the history of the changes was put into a little verse to jog the memory. Congress decided at first to fix the number of justices at 6. Congress planned on a change to 5, but the 6 remained very much alive. 6 high judges, supreme as heaven, and Jefferson added a number 7. 7 high judges, all in a line. 2 more added, and that made 9. 9 high judges were sitting when Lincoln made them, and even 10. 10 high judges, very sedate. When Congress got through, there were only 8. 8 high judges who wouldn't resign. President Grant brought the figure back to 9. Would a justice feel like a packed sardine if the number was raised to, say, 15? Well, the last line of this little verse marks the so-called court-packing plan of Franklin Roosevelt. And citing the heavy workload and declining age, or advancing age, I should say, of many of the Supreme Court's then-sitting justices, President Roosevelt suggested the increase that would have raised the number to 15. However, I think historians have long focused on what's widely believed to be the real reason for the plan. He was more than a little annoyed that the justices were giving a thumbs down to so much of his New Deal legislation, and he was not imagining things. In the 140 years between 1790 and 1930, the court had overruled only 60 acts of Congress, barely half an act a year. But during President Roosevelt's first term, the court held unconstitutional 12 laws, and some of those were the president's favorites. Indeed, on the aptly named Black Monday, May 27, 1935, the Supreme Court struck down 3 pieces of legislation all at once. At that pace, President Roosevelt feared the court would soon dismantle his New Deal altogether.